Before I introduce our speaker, I have a few logistic issues to cover. This CME activity is jointly provided by the Queen's Medical Center and the UH Jabsum Department of Geriatric Medicine. At this time, please enter the name and credentials of everyone viewing Grand Rounds for CME attendance purposes. As a reminder, evaluations are required for CMEs. You can find our evaluation form by following the link in the chat at the end of the session or at any time on our website or on our email advertisement. We are currently offering CME for MDs and DOs, RNs, APRNs, and physician assistants. I have good news to share. We are happy to announce that you can download your own CME certificates anytime by going to the Queen's Medical Center website at www.queens.org and typing in capital CME in the search tool. Annual transcripts will no longer be sent out because you can download your own. Dr. Peace has said that he has no disclosures to make regarding conflicts of interest with regard to this presentation. It is my great honor to introduce Professor James Peace, JD. He's a professor of law at the William S. Richardson School of Law and an adjunct professor of geriatric medicine at the John A. Burns School of Medicine at the University of Hawaii, Manoa. He received an AB degree from Georgetown University in Washington, D.C., and a JD degree from the Catholic University of America in Washington, D.C. He joined the faculty at UH after first having served on active duty in the U.S. Army Medical Service Corps and the Judge Advocate General's Corps, and subsequent having served as the directing attorney of the Honolulu Elder Law Unit of the Legal Aid Society of Hawaii. At the law school, he teaches law, aging and medicine, elder law clinic, health law, and advanced health law. He supervises the UH Elder Law Program, also called UHelp, which provides year-round direct legal services at the law school to underrepresented older persons and veterans, as well as their caregivers. Please join me in welcoming Professor Peace. Jim, it's all yours. You can take it away with your slides.
Thank you very much, Kamal. I really appreciate that kind introduction and always the opportunity to talk to geriatric medicine and other individuals who are interested in patient care for older persons in our community. I'm going to be talking today about guardianship and conservatorship and their alternatives with a view to stressing alternatives and stressing how important I think it is to have the whole patient-client working team working together. So various professions working together, of course, doctors, nurses, PAs, social workers, other members of the healthcare profession, but also lawyers and financial representatives in the community who help older persons navigate growing old in a very changing world and sometimes unpredictable world, not only for themselves, but as a country and as a state, because laws do change. And I'll be talking about a proposed law towards the end of this session. But I think it's important that we all work together as a team, and we help each other. And we know that that people should be referring and also consulting with each other in the areas that I'm going to be talking about. So some of the general concepts that I'm going to be covering today is guardianship and conservatorship. And the first item is that they provide the legal mechanism by which a judgment of a more capable person is substituted for the judgment of an incapacitated person. And those would be decisions necessary to manage personal affairs and property. And personal affairs includes healthcare decisions and healthcare decision making. Only a court can appoint a guardian for what is called a ward in the guardianship process, or a conservatorship, what is called a protected person. The court adjudicates incapacity. However, the court relies on testimony by a healthcare professional, and that's usually required. Sometimes it's just apparent that the individual is no longer capacitated, but generally, the court proceeding in order to appoint a guardian or a conservator requires testimony by a healthcare professional, with a few exceptions that I'll talk about in conservatorship. Generally, it'd be a psychiatrist, a psychologist, other professional with skills to assess the subject's alleged incapacity. So a variety of individuals are providing testimony to the court. It's becoming more than just what most people in the past commonly saw was a page or two. The courts are requiring more evidence, and they're seeking more information, generally speaking, because the judges are balancing autonomy and self-determination and protection and best interests while they're trying to be efficient, and they do take seriously the opinions of the healthcare professional who is providing the testimony, but they need to make certain that the appointment of a guardian or conservator is appropriate. Occasionally during my session today, I'm going to be talking about a few areas that may be that you may be unaware of with respect to the appointment of a guardian or a conservator. The judges are making this decision of whether to appoint a guardian or a conservator, but very often they never see the patient or the client or what we call the subject of the proceeding. So it's an interesting concept where the judge is making a decision over somebody that they may not have ever seen. Attorneys very often will ask that the individual be there. Of course, the individual has a right to be there, but it's not required, except the judges will require the presence of the individual in cases that are especially contested cases, and where the individual may or may not have sufficient lack of capacity, let's put it that way, to understand what's going on. So the judge very often under those circumstances will want to talk with the individual. There's a threshold of what is an incapacitated person under the law for both guardianship and conservatorship. It then splits into two different areas of guardianship and conservatorship for the specifics, but the general threshold for an incapacitated person is defined as an individual who, for reasons other than being a minor, is unable to receive and evaluate information or make or communicate decisions to such an extent that the individual lacks the ability to meet essential requirements for physical health, safety, or self-care, even with appropriate and reasonably available technological assistance. I'll pause once again just to add a little insight into this. This law comes from the Uniform Probate Code that Hawaii adopted in 1997, and it has been modified. The guardianship and conservatorship areas in the Uniform Probate Code have been modified over the years, but initially what the Uniform Laws Commission had suggested, and I'll go to the bottom of this slide, where the original draft was even with appropriate technological assistance. Well, certain individuals or organizations, agencies, let's put it even better, did not want to have to provide technological assistance that was rare. You think of Stephen Hawkins, for example, who had all sorts of marvelous technological assistance. So they were afraid that it would be cost prohibitive. So they appealed to the legislature to put in reasonably available technological assistance. So it's just an indication that guardianship and conservatorship, as with basically all laws throughout the country, are subject to uh, political influence and changes, and that's good. Sometimes it goes in favor of one side or the other, but it's subject to change, and that's the dynamic that we see in most laws, that most state laws, including our healthcare laws. But in this case, the probate code, guardianship and conservatorship. The Hawaii courts have jurisdiction over guardianships for individuals domiciled or present in the state, and conservatorships for individuals who are domiciled or own property in Hawaii. At the University of Hawaii Elder Law Program, or UHELP, we very often get calls from the mainland, and this is one of those calls that we get is concerning individuals who own property here or there, but they're neither here nor there, and whether or not the courts here would have jurisdiction, or which state would best have jurisdiction. It's a complicated matter when you have the potential ward or protected individual in one state, and especially if the individual who wants to be conservator or guardian lives in another state, or there's multiple properties around different states. So various states may be involved, but increasingly the states have come together with compacts and changes to their own laws to make that possible, to make it easier to deal with the realities of the modern world, especially for property. For guardianship, the courts also have the ability to, even after a guardianship, where guardian of the person and the individual needs to go to another state, or the guardian wishes to bring them to another state, there are agreements among states, not all states, but among states, to make it easier to make that happen. Guardianship cases are usually held in the family court. Now, the family court on Oahu is out in Kapolei. On neighbor islands, it's not as complicated because you have more of a central circuit court and family court together. But on Oahu, it's been a great transition for lawyers since the family court opened out in Kapolei. So there are planning issues for attorneys who either want to take a case or not want to take a case based on geography, because many attorneys don't want to travel out to Kapolei for a short hearing on a family court. I must say that for all of us, the COVID-19 pandemic was awful. Let's put that first. But it brought technological advances like Zoom and other internet capabilities. And for long periods now, during COVID and after COVID, many of the hearings have been held via Zoom or WebEx, and consultations through different internet capabilities. But there's a trend to bring the court matters back to the court. So this is one of the things that attorneys think about when they're thinking about whether to take on a guardianship. The interesting thing about conservatorship cases is that they're held in the circuit court. So it's a completely different court. On Oahu, it's the probate court of the First Circuit, but the circuit courts we have on each of the in each of the circuits on different islands. But guardianship and conservatorship cases may be consolidated in the circuit court. So there's a lot of planning around that too. So the attorney may say, well, do you also need a conservatorship if somebody came in just for a guardianship? And if they say yes, the attorney, the downtown attorneys, let's put name those, um, uh, may say, okay, that's fine, because they can consolidate the case into a single matter downtown on Punchbowl Street in the circuit court, and it makes it a lot easier for them. In the statute, you may read that it can be consolidated in the courts, but it's in practice, it's only in the circuit court. But it is something that attorneys think about. They'll take a guardianship and conservatorship, and because it's easier to go to the circuit court. So it's a matter of geography, it's a matter of jurisdiction, it's a matter of who gets to hear the case. Once again, the family court takes care of guardianship of the for the personal matters, and the circuit court takes care of conservatorships for the fiscal, the land, the monies, other aspects of the individual's life. Now, for guardianship, the court may appoint a limited or unlimited guardian for a respondent, and this is where we start thinking about alternatives to guardianship. One of the alternatives to a plenary guardianship, that means a guardianship over all matters concerning the person of the individual who needs help, is to appoint a limited guardian for that individual and let the individual do other things for themselves. In the old days, it was most common just to appoint a guardianship when one spectrum, one area of the person's life needed to be taken care of when they couldn't take care of it. But the courts are supposed to look at alternatives, and a limited guardianship is one of those alternatives. The court may appoint a limited or unlimited guardian for a respondent only if it finds clear and convincing evidence that the respondent is an incapacitated person and the respondent's identified needs cannot be met by less restrictive means, including the use of appropriate and, once again, reasonably available technological assistance. Clear and convincing evidence is a very high standard of evidence that's required. We'll see in conservatorship, we'll see some mention of preponderance of evidence, but just as a quick review, preponderance of evidence is a lower standard, and it's more likely than not. It doesn't equate to, but you can think of it as 51% or they need some help. But clear and convincing evidence is a much higher standard. The highest standard applies in criminal cases where you need to have evidence beyond a reasonable doubt. Another little side note is that there is a civil matter that does require clear and convincing evidence, and that is an associated areas for some individuals who lack capacity, and that would be involuntary civil commitment. That requires that evidence that an individual has a mental disorder or drug abuse, etc., and that the individual is imminently dangerous to self or others, and that there is no suitable alternative. That's just a nutshell of civil commitment. It's related, but it's not the same as guardianship. It's where the state will take command and indicate that the individual needs to have involuntary hospitalization or treatment. But that's just an example of the differences in the levels of evidence that need to be provided. Second requirement is, again, that the identified needs cannot be met by less restrictive means. And I won't talk about the technological assistance at this time, but that will include whether or not there are suitable alternatives also in place that I will talk about. So, for example, for healthcare decision-making, if the individual has an advanced healthcare directive, and that's the only thing they need for, to be taken care of, then the court may not find it suitable to appoint a guardian. But we'll go through several of the alternatives to guardianship and conservatorship, and you can see where in some instances the individual may have everything down except for one thing, and then even under those circumstances, the judge can appoint because it may be a very important aspect of the person's life. Conservatorships are interesting for a variety of reasons. The appointment of a limited or unlimited conservator or other protective order in relation to the estate and affairs of any individual, including a minor, may be made if the court determines that for reasons other than age, by clear and convincing evidence, that same standard that we saw with guardianship, the individual is unable to manage property and business affairs effectively because an impairment in the ability to receive and evaluate information or to make or communicate decisions, even with the use of appropriate and reasonably available technological assistance, or because of another physical, mental, or health impairment, and then something that's unrelated to mental incapacity or because the individual is missing, detained, or unable to return to the United States. So that adds a different component where the judge has the ability to appoint a conservator. And we have had a few cases that were brought to our attention of the missing person. And then when you add to the clear and convincing evidence, then you continue with, and by a preponderance of evidence, the individual has property that will be wasted or dissipated unless management is provided or money is needed for the support, care, education, health, and welfare of the individual or the individuals who are entitled to the individual support, and that protection is necessary or desirable to obtain or provide money. So this adds a different dynamic to the area of conservatorship, where it's not just the individuals unable to manage, but it can also be for reasons that the individual is wasting property or dissipating it, or may dissipate money unless management is provided. So this is where families can request a conservatorship because the one family member who is responsible for that individual's support is not receiving money. So spouses, minor children are not getting the support because the individual is wasting it, wasting the monies, using it for, it could be drugs, it could be gambling. So there are many reasons. So conservatorship is a very dynamic area of different types of individuals who may come under the jurisdiction of the courts. A guardianship and conservatorship will last until the death, resignation, or removal of the guardian or conservator, or when the court determines the guardianship without regard for location of the guardianship or conservatorship or the ward. So we have had instances where the court terminated the guardianship when, after a couple of years, we had one case where the individual was, they had a plenary guardianship over them, and they said, but I take the bus. I have a job. I don't want this guardianship anymore. And so the case was made, and the judge dissolved the guardianship. I should note, especially for healthcare providers, emergency guardianships and conservatorships for a specific person are available. And you mention a little later on more about that. Don't count on emergency guardianships for your healthcare decision-making abilities necessarily, but I'll go into greater detail about the backlogs of the court. But these emergency guardianships and conservatorships for specific persons are not intended to last indefinitely. So in general, guardianships and conservatorships last until the death, resignation, or removal of the guardian, or when the court terminates the guardianship. But emergency guardianships are intended for limited periods of time. A long time ago, it used to be that when a hospital or other healthcare provider needed an emergency guardianship, they could get it relatively quickly. I remember one of the judges telling me they had a beeper in those days, and they were available to hear cases, but it now takes weeks or months to get even an emergency guardianship. Conservatorships for a specific purpose are linked very closely, especially in the area of geriatrics, where there is a need to get at the individual's money in order to provide services, to pay for the mortgage, to pay for to pay for a caregiver, but nobody has access to that bank account. So the conservatorship for a specific purpose, a petition can be made for a specific purpose. For example, to have access to such and such bank account, and this is why we need it. And then you give the evidence that the individual lacks capacity, is unable to manage their finances, and that is a not commonly known. That's not a commonly known procedure, but it's a very effective tool to get into that bank account, and then it doesn't involve getting a whole plenary conservatorship over the individual. That may come later, but it's the ability to get into the account, for example, much more quickly. And that seems to be working more smoothly than the family court. The family court is very much limited in what it can do because the vast number of issues they deal with, divorce, child support, child protective services, adult protective services also, but they are overwhelmed and they never have enough judges, even though the judiciary always asks for more judges. The legislature has not appropriated sufficient monies to provide the services to the community for those types of matters. Okay, I'm going to talk a lot about alternatives to guardianship and conservatorship, but I'd like to express some positives first, and then we'll get back to the negatives, but some positives for guardianship. Positive is that there's a court order when either a guardianship or a conservatorship is pursued, and the court appoints a guardian or a conservator. Banks and everybody else seems to take notice when there's a court order appointing an individual and given certain authority, and the authority can vary depending on the court order itself, but it's less question than some of the alternatives I'm going to be talking about. There is court supervision in the sense that the guardians and the conservators have to file periodic reports, and for conservatorship, for example, how the monies are being spent. And so there is a continuing court supervision. The court won't act on its own to look into matters just to make sure everything's going well under most circumstances. So they rely on the reports that are sent in by the guardians and the conservators. What is done with the reports, how deeply they're looked into, may be another matter that I think varies depending on the volume of the reports that are made every year and the staff that's available to review all of those reports. Talking to a couple of clerks of the family court over the years, it seems to be pretty difficult for them to keep up with all of the reports that they have. The negatives, number one for most people, are the dollars. Now, there may be some law students in the audience today because they were invited to attend. For law students, that sounds good. Thousands of dollars to go for a guardianship or conservatorship. I'll give you an example at the extreme. Princess Abigail Kawananakoa's case that just a couple of years ago went through conservatorship, and she alone expended over $2 million, I do believe, that's what the report was in the papers, of her monies trying to defend herself and hiring lawyers and then having new lawyers appointed. Now that's not going to be the cost for everyone, but it's an expensive process when you have attorneys representing individuals in court doing investigations, and especially if it's a highly contentious case. But for most guardianships and conservatorships, they're not contested, but it doesn't mean they're not going to be expensive. So it'll be several $1,000s. It takes a lot of time, plus or minus 6 months for a guardianship to even be heard. I think that's getting better now, but post-pandemic, that's what it was running, and then it's frustrating. Dr. Masaki was saying that there are individuals in healthcare facilities that she told me about that have been in there for a year waiting for a placement to get out of the acute care facility. And it's tremendously expensive to keep somebody at a care level that they don't need, and it would probably, in many instances, it would be better for the patient to be in that lower level of care. Um, but it takes so long to get that appointment of a guardian or a conservator. The conservatorships, I understand, take a lot less period of time, and that may be another reason that the attorneys like to consolidate cases when the individual hasn't made any plans for the future and needs both a guardianship and a conservatorship. A big negative, and it'll be one of the topics in the last portion of my presentation today regarding future changes, is the potential deprivation of rights and autonomy of the individual. Basically, what you're doing when you're appointing a guardian or conservator is you can think of it at least as appointing another parent over a child, not a child, of course, because this is for adults, but they lose many of their rights and the ability to choose where they live, what healthcare decisions they make, and how they spend their money. So it's that is especially worrisome when the individual still has some ability to make decisions, but does have diminished capacity. And I'll talk a little bit more about those issues as we look at the proposed changes to the guardianship and conservatorship law a little bit later. Now, for the alternatives to guardianship, you already practice this, healthcare providers in the audience already practice this when you encourage individuals to make advanced healthcare directives. At least, you can't force them to because both federal and state law prohibit you from requiring the execution of an advanced healthcare directive as a condition of treatment. Um, and but you do stress it, and for those uh, who make them, it makes life a lot easier. One of the um, issues that comes up in that arena is that yes, people are planning ahead, and I'll start off with the Advanced Healthcare Directive, but they're not planning for the absolute worst that could happen to them. And we're seeing this increasingly as the population gets older and older. And that will be where for an advanced healthcare directive, naming an agent, and that agent also becomes mentally incapacitated. And there's either no follow-up advanced healthcare directive to appoint or nominate a successor agent, healthcare agent. So that also needs to be stressed, that sometimes that individual will not be available, will not be alive perhaps, or not be willing to act as agent. So our motto at the University of Hawaii Elder Law Program is plan for the worst so that you can expect the best. So we'll now go through the list. We're going to divide it up into personal and financial matters because that's the way that the court divides it up to personal matters, which would be guardianship, and financial matters, which would be conservatorship. So for personal matters, we start off with legal and financial powers of attorney, because there are many matters that need to be dealt with that are not healthcare matters, but can be dealt with through a legal and financial power of attorney. In 2014, the law changed to dramatically change how powers of attorney are executed, their powers, and also that healthcare powers are no longer included or may no longer be included in the legal financial powers of attorney. So the laws do change periodically in this area too. Um, Another alternative to guardianship is I have been talking about the Advanced Healthcare Directive. So for both the Advanced Healthcare Directive, where you have the individual instructions for healthcare that you will follow, you healthcare providers will follow upon incapacity of the individual, or if they're not clear, um, of the agent that's appointed in the healthcare directive. Um, Same problem with the extra thinking about what happens if my agent is no longer able to act. You have that same issue with the legal and financial powers of attorney. Luckily for guardianship, for healthcare matters, there is a surrogate decision-making statute in Hawaii. It's rather complex, but most of you know about it. But if there is no guardian and if there is no healthcare agent, for surrogates under the law can make healthcare decisions for incapacitated adults, and those are they can be designated directly by the patient to you as a designated surrogate. And then there's a long process, the topic for another grand rounds of the selection by consensus of interested persons. And the reason I mention this matter is because some individuals in the community um, don't realize that there is no family consent statute as they have in many other states, where the family members can make decisions in under a list, a hierarchical list of the spouse, the child, parent, etc., to make decisions for an individual. So I keep on hearing where individuals are asking so-called next of kin to make decisions. But what you need in Hawaii for an advanced healthcare directive, for healthcare decision making, is a legally authorized representative. And one other thing that many people neglect or don't know about is that healthcare providers are required to have the surrogate provide facts and circumstances under penalty of false swearing, how they were appointed as a surrogate under Hawaii law. Now, to the conservatorship side, there's an overlap, we'll see, with powers of attorney, but living trusts are a very good alternative to conservatorship, because living trusts, which have often been used to avoid probate, to attempt to avoid probate for matters that are placed into the trust, are excellent also to provide management of assets when the individual becomes mentally incapacitated. And a successor trustee then can take over and manage the property. And then upon the death of the individual, can distribute the property without having to go through probate. So it's a great tool that attorneys have for both estate planning and for as an alternative to conservatorship. Powers of attorney, that's one of the major tools that can be used with or without a living trust to manage finances for an individual. I mentioned the 2014 new law for powers of attorney, and it makes it a lot easier to have the power of attorney recognized by an agency or facility I'll give an example of the bank that says no, used to say no all the time, and now they have to say yes unless they have some specific reasons to doubt uh, the uh, the uh, the validity of the document, or it needs to be translated, or they believe that there's fraud. So the law has flipped in that area. Now it is now there's a requirement that it be recognized under certain circumstances. And one of those circumstances is that it be notarized. Joint accounts and property is a common tool that people use to manage their finances, and some use it as an alternative to estate planning. There are some dangers with all of these alternatives, but for joint accounts and joint property, it's a big danger because if it's, for example, a bank account is joint tenancy with rights to survivorship, then that property belongs to the joint owner, and that joint owner can get into that account and spend that money. And we see very often the intention was to help with the finances, but what happened was all the money was taken out, or the other family members are really upset that that person got that big bank account or other financial um, account or a document when it was joint tenants with rights to survivorship. And it's uncertain whether that's what the individual who owned it originally had intended. Uh, so property management, uh, automatic bill payment services, you can think of many other alternatives to help set things into place. And of course, a very good resource is to have an individual go to an attorney to set up these basic alternatives to both guardianship and conservatorship. And that helps families, it helps healthcare providers, it helps banking institutions, it helps make it smoother transition when a person is incapacitated. So now I'm talking a few minutes about supported decision making, and that's an alternative to guardianship, and that's what um, courts are leaning more towards, is looking at supported decision making, having supports to individuals so you don't have to take away all their rights through guardianship and conservatorship, but especially guardianship for their if they just need some help. Some states have already gone and enacted the Uniform Guardianship, Conservatorship, and Other Protective Arrangements Act. We have not. It's been going on a couple of years in the legislature, and they're meeting almost as we speak this month, a committee to once again attempt to convince the legislature that this is important. What the new change to, if they enact this, to substitute for the Uniform Guardianship and Protective Proceedings Act, which we now have, this new law would encourage courts to impose the least restrictive orders possible to adequately protect vulnerable minors and adults, and to monitor the protective arrangement to continuously adapt to an individual's changing capabilities and needs. So it would require the courts to be more active in the appointment, but also the management and the adaptation that may be required, and the courts would monitor this area. It would impose clear duties upon guardians and conservators charged with protecting others, and requires regular monitoring to ensure compliance. The regular monitoring is rare in current guardianships and conservatorships. And it allows courts to address specific problems with limited orders and preserve individual rights when possible. And it requires a court to determine whether supported decision-making is an appropriate, less restrictive alternative. About almost 20 states now have supported decision-making statutes. Hawaii does not have that statute, but it provides a mechanism and an infrastructure to provide assurances that an individual will receive assistance in making decisions. So it could be an aide, it could be a social worker, it could be some other mechanism through which the individual is provided individualized care to help them make decisions for themselves. So it requires a very dramatic change in philosophy on guardianship and conservatorship. And I think the limitations on the court's budget is one of the things that's going to come up over and over again next legislative session. But there's a very good group of individuals who are going to be lobbying the legislators to basically to provide for this new mechanism. And this is an approach that has been taken in various countries in Europe, Australia, other places, and it seems to work very well, but it's much more expensive. Okay, so we do have time for questions, and thank you very much for your attention to these slides.
Dr. Peach, thank you so much for a wonderful presentation. I know there are already some questions in the chat. I see the first question is from Pedro. Pedro, would you mind unmuting yourself and asking your questions?
Yes, can you hear me now?
Yes.
Oh, perfect. Yeah, thank you for the great talk. I think you answered both questions I had in the chat as the chat went on. So, but I do have a follow-up question. I've seen a case where a lot of family members are concerned about the financial risk of assuming, mostly in like appointed being an appointed surrogate. So I wonder if you could speak to that. Is there like a financial liability for surrogates and also for conservators or guardians?
Yes, generally speaking, the guardian or conservator or agent under a power of attorney or a trustee don't assume personal financial liability. It's such a fear, however, and some institutions really push that they do accept financial responsibility. So that's why we in our advanced healthcare directives put that, however, my agent does not assume any personal financial responsibility for actions under this. So, placement in a nursing home. We tell people to read nursing home contracts very carefully. It's getting better, but there's very often a place in there where the individual who, they ask the individual to accept responsibility, and then somewhere there's a phrase in there that if Medicaid doesn't come through or if they run out of money, you are going to pay for this, and they sign off on it. And we've seen some of these things, and it's really very nasty stuff. And I know nursing facilities and other institutions want to get their monies, but when you have somebody who's volunteering to be an agent or a guardian or a conservator, that's the last thing they want, because they're already providing extra work and time. And I'm sure that many, family members are spending their own money, but to lose their home over it because of the, after a year of nursing facility care, that's hundreds of thousands of dollars that could be. So Um, Generally speaking, they're not, but many attorneys will place that into the document. Hawaii law for Medicaid, for example, does does say the law does say that um, children are not responsible for their parents' um, bills, and but parents are responsible for minor children, but not for their adult children who may live in the basement. But it's clear that under Medicaid, you don't go after the child who perhaps will be the agent. In some states, there are filial responsibility laws. But in Hawaii, we don't have that. And in some countries, it's very strict, such as in Singapore, but we don't have that here. So um, if there's some doubt over it, it should be put into that document that, no, Dad, I don't want to accept personal responsibility. Could you have the lawyer put something in there?
Dawn, would you like to unmute yourself for your question?
Yes, thank you very much. My question is, in order to pursue conservative and guardianship, can it be done without a lawyer? And if so, how does one start? Especially there are so many without any finances. And then on top of that, will you help guide these individuals?
Well, we no longer have the federal funds under the Older Americans Act that we used to have. That all went to the Legal Aid Society. So they are the go-to persons to ask about guardianships and conservatorships. But second of all, in that arena, there is a nonprofit that does guardianships and conservatorships because most of the time legal aid will refer people back to us, but we don't have that grant anymore. So no, we don't pursue guardianships or conservatorships, but an organization called Maximum Legal Services or Maximum Legal Services Corporation or MaxCorp does provide guardianships and conservatorships. And I'm not sure what the sliding scale may be. I think they're a not-for-profit organization to make it a little less expensive. But that's the confounding thing. Unless the state petitions for a guardianship, and they can, but that's only at the request of, for example, Adult Protective Services and other agencies, because uh, the state does not represent individuals, but they can petition for under an Adult Protective Services where protection is needed. But it's that's the other real problem is access to justice for every area of the law. There's just not enough funding to the majors, and then we're sort of a small group. We specialize mainly in education and training these days, but we're no longer able to do guardianships and conservatorships.
Thank you very much.
Sure.
Thank you, Jim. Obviously, a very complex problem still for our state. Yeah. It doesn't look like there are any other questions. We have time for one more question. If anybody wants to unmute, please do so. Thank you, John. John just put the evaluation link into the chat box. So don't forget to do your evaluation because you need that to get your CME. I want to thank Professor Peach for a wonderful presentation. He has agreed to come back another time for other topics. So please let us know if you have any specific topics, legal topics that you would like him to address, and we will definitely bring him back another time. Thank you so much, Jim.
And thank you, Kamal, for inviting me. And yes, I do look forward to future grand rounds. There are a whole bunch of areas. And Dr. Masaki's team, they're gearing up for our annual legal ethics seminars in the spring, and in that we have so many topics. So if you're unsure of a topic, just ask that department, what topics would you suggest? And there's always more to talk about. This is about a half semester that I should be covering these matters today, but so it's just skimming the surface of some of these issues, and then there are wide range of other issues,
Thank you
including.
so much, Jim. For the rest of our audience, Dr. Susan Christensen from our department, she's the faculty member who's championed the Law and Ethics series for the fellows, as well as for other healthcare professionals. We have nurse practitioners, social work, other students joining us as well. So Susan does that every spring with the whole team, and Jim is very kindly agreed to be part of that team. Thank you all so much. Okay, bye everyone.